In a stunning turn of events, former Florida Attorney General Pam Bondi took to the Senate hearing room to accuse Supreme Court Justice Coney Barrett of a secret deal that could compromise her impartiality. The room fell into a stunned silence as Bondi laid out explosive claims, backed by what she called undisputable evidence, suggesting that Barrett had made undisclosed promises to powerful political figures during her confirmation process. As Bondi's words echoed through the chamber, tension thickened the air, and every eye turned to Barrett. The stakes had never been higher, and the atmosphere was electric with the weight of her response. Would Barrett's reputation withstand the barrage of accusations, or was this the beginning of a scandal that would shake the very foundation of the Supreme Court? Pam Bondi's unyielding confidence. As former Attorney General of Florida, Bondi was no stranger to controversy. Throughout her tenure, she had built a reputation as a formidable prosecutor with an unwavering commitment to conservative values. Her work on high-profile cases involving corruption and fraud had earned her a reputation as someone not afraid to fight hard for what she believed in, even if it meant taking on powerful political forces. Her career had been a blend of legal acumen and political maneuvering, and she had spent years navigating the complex intersections of law and power. It was perhaps this background that made her the perfect figure to deliver what could be the most explosive revelation in the history of Supreme Court nominations. Bondi's approach to the matter was methodical and deliberate. She knew the stakes, and she knew that the moment she stepped up to that podium, she would be taking on the very institution she had spent her career in government protecting. When Bondi entered the hearing room, her presence commanded attention. She moved with purpose toward the witness table, the cameras flashing as she adjusted the microphone in front of her. Her attire, an impeccable blue blazer, stood in stark contrast to the wood-paneled walls of the room, symbolizing a figure of authority ready to lay bare the truth. As she spoke, her voice carried the weight of her conviction. "Thank you for allowing me to speak today," she began, her tone calm but unyielding. "I come before this committee with evidence that will change everything we thought we knew about Justice Barrett's appointment process." The moment of revelation. As Bondi pulled out the sealed folder, labeled "Confidential" in bold red letters, the room fell into an eerie silence. It was as if time had momentarily suspended itself, every person in the room fully aware that what they were about to witness would be anything but ordinary. Justice Coney Barrett, sitting across from Bondi, remained composed, her face inscrutable. The calm facade she maintained was a hallmark of her career. Barrett had built her reputation as a stoic and methodical jurist, always composed under pressure. But as Bondi opened the folder, the slightest flicker of unease appeared in her eyes. Before Bondi could even begin to present the first piece of evidence, the entire committee leaned forward in anticipation. The chairman's hand instinctively reached for his gavel, ready to bring order to what was sure to be a tumultuous moment. But it was too late. Bondi had already begun her revelation. With precision, she outlined what could potentially be the biggest scandal in the history of Supreme Court appointments. "What I am about to reveal," she said, "shows a secret arrangement that occurred before Justice Barrett's confirmation, an arrangement that she has never disclosed to this committee or to the American people." The documents. Evidence of a hidden agreement? The documents Bondi unveiled were nothing short of explosive. The first, an email exchange between senior officials in the Trump administration, was dated September 18, 2020, less than a month before Barrett's nomination was officially announced. Bondi projected the contents of the email onto a screen, allowing the members of the committee to read the carefully worded but unmistakable text. The email discussed a mutual understanding regarding how Barrett would approach certain cases should she be confirmed to the court. Although the email was cleverly worded to avoid directly implicating Barrett, the language strongly suggested that specific legal positions were discussed, positions that Barrett would adopt once confirmed. At first, Justice Barrett appeared unfazed, but her eyes betrayed a growing sense of concern. She leaned forward, adjusting her microphone as she addressed the committee. "These emails," she began, her voice steady but edged with uncertainty. "If authentic, do not include me as a recipient. Ms. Bondi, I never participated in such discussions." Bondi nodded, acknowledging Barrett's statement but not backing down. "That's correct, Justice Barrett," she replied. "You're not directly copied. However, the next document addresses that point." She held up the second piece of evidence, a calendar entry detailing a private meeting scheduled between Barrett and the officials in question, scheduled just one day after the email exchange. The committee chairman, visibly unsettled by the turn of events, interjected. "Ms. Bondi, suggesting impropriety based on a calendar entry is speculative at best. Supreme Court nominees meet with administration officials all the time." The shocking admission. The room was stunned. Senator Josh Hawley, who had remained largely silent until this point, could no longer contain his growing concern. He turned toward Barrett, his voice filled with urgency. "Justice Barrett," he said, "I need to ask you directly. Did this meeting occur as described in this memorandum?" Barrett's response was measured but tense. "Senator, I took dozens of meetings during the nomination process," she began. "I cannot recall the specific content of each, but I can state unequivocally that I never made commitments about how I would rule on future cases that would violate judicial ethics." Bondi pressed further, undeterred by Barrett's deflection. "Justice Barrett, please look at page 6, paragraph 3 of the memorandum," she said, her voice now laced with intensity. "It specifically mentions your concerns about how these discussions might appear if made public." Barrett, seemingly caught off guard, glanced down at the document. The passage in question was a direct reference to Barrett's concerns about the potential public fallout from such a meeting. It stated that she had requested absolute confidentiality regarding certain aspects of the discussion, citing the possibility that they went beyond the typical scope of a Supreme Court nominee's confirmation interviews. The crossfire of allegations, Senator Ted Cruz, a staunch defender of Barrett, was quick to intervene. "This entire presentation is based on unauthenticated documents from anonymous sources. In what world is this appropriate material for a congressional hearing?" Bondi, unshaken by the criticism, calmly responded, "Senator Cruz, I understand your concern. That's why I've had these documents examined by 2 independent forensic analysts." She handed over affidavits from digital forensics experts who had confirmed the authenticity of the documents, their metadata verified as legitimate. Bondi then dropped her final bombshell, another document that would solidify her case. "I have a sworn statement from someone who was present at this meeting," she revealed. A former mid-level Justice Department official who had been taking notes during the meeting but had only recently come forward due to concerns about recent Supreme Court decisions aligning precisely with the commitments outlined in these documents. The moment of crisis. The room was now a maelstrom of conflicting emotions. Democratic senators huddled in whispered discussions, their faces a mixture of disbelief and intrigue. Republicans, too, were split, some fiercely defending Barrett, others quietly distancing themselves from the scandal that was unfolding before them. Justice Barrett, ever the professional, requested a brief recess to review the materials with her legal team. The chairman, understanding the gravity of the situation, quickly granted the request. As Barrett and her counsel exited the room, the tension was palpable. Cameras captured the strained expressions of committee members, their faces betraying the shock they were all trying to conceal. When the hearing resumed, Justice Barrett was no longer the composed figure who had entered the room just hours earlier. She was visibly shaken, and her legal counsel handed her a handwritten note as she took her seat. The atmosphere had changed. The once unflappable Justice Barrett now seemed uncertain, as if the walls that had once supported her judicial calm had begun to crack. "Justice," the chairman began, his voice tinged with a sense of urgency. "The floor is yours." Barrett, after a long pause, spoke with surprising composure. "I've had the opportunity to review Ms. Bondi's documents," she said, her voice firm but careful. "Despite the circumstances, I take these allegations extremely seriously, as they strike at the heart of judicial independence and the oath I swore to uphold. I believe the integrity of the court requires a thorough investigation of these claims." The room went silent. No one had expected such a response. Many had anticipated an emphatic denial from Barrett. But what they heard instead was an unexpected acknowledgement that the situation required further scrutiny, a statement that, in itself, suggested the potential for an unprecedented investigation into the integrity of the Supreme Court and the legitimacy of its most recent appointee. Barrett's response: "Calm in the storm." As the documents appeared on the projector screen, Barrett's face remained unreadable, even as she quickly recognized the familiar handwriting that adorned the pages. Her expression, once firm, shifted as she processed the information. The room's tension was palpable. Journalists whispered, their cameras poised to capture the slightest hint of vulnerability or weakness in the judge. For a moment, it seemed as though the allegations were about to land a devastating blow to Barrett's credibility. The note, clearly marked with her distinctive handwriting, contained abbreviations and annotations that suggested a troubling narrative. A narrative that was quickly being spun by Bondi and her supporters. But Barrett, a woman known for her disciplined nature and unflappable demeanor, refused to let the gravity of the situation overwhelm her. She stood slowly, deliberately, and walked toward Bondi's table with an air of resolve. Her eyes flicked over the document, now under the harsh glare of the overhead lights, and she gestured for her legal counsel to join her. As she studied the document, her expression shifted from doubt to recognition, a slight furrow appearing between her brows. Barrett's legal mind was already at work. After a brief but intense whisper with her team, she returned to her seat, ready to dismantle the allegations piece by piece. A subtle, yet decisive dismantling Barrett's voice broke the silence, calm but filled with an undeniable authority. "Mr. Chairman, members of the committee," she began, her words measured. "This document is familiar to me, but the context in which it has been presented is not." Her eyes swept over the room, locking onto Bondi with the precision of a skilled litigator. "This appears to be a page from my personal preparation notes," Barrett explained, each word carefully chosen to disarm the accusations. "Before my confirmation hearings, I kept extensive notes, just as any nominee would. These were not secret meetings or covert conversations. They were my legal preparations, preparing for the rigors of being questioned before this very committee." Barrett paused, allowing the weight of her statement to settle in. She reached into her own portfolio, pulling out several similar pages of notes, all marked with the same distinctive shorthand. As she laid the papers on the table, she turned them over to the committee clerk, a visual testament to her assertion. "Here," Barrett continued, "you will see the same abbreviations and marking system. The Confiarch notation refers to confidentiality, not to any secret confirmation process, as Ms. Bondi has implied." Barrett's gaze never wavered from Bondi, who had begun to shift uncomfortably in her seat. She had anticipated this kind of attack. and now she was methodically diffusing it. The evidence against the evidence. A technical triumph. The room grew quieter, the tension thickening as Barrett pressed on. She turned her attention directly to the memorandum Bondi had presented, her eyes scanning the printed words one last time. "As for the meeting summary," she said, her voice gaining strength, "I cannot explain its origins, but I can unequivocally state that it misrepresents any conversations I had during the nomination process." Her tone was firm, unwavering. "I would never make commitments about future cases, especially in ways that would compromise the judicial oath I have honored throughout my career." The committee, which had been on the edge of their seats just moments before, was now watching in silence. Bondi, who had been riding a wave of public opinion just minutes earlier, appeared visibly rattled. Her carefully crafted narrative was crumbling in front of the nation. But Barrett wasn't finished. "You mentioned a whistleblower," she said, turning her attention to Bondi. "Someone who allegedly took notes during this supposed meeting. My question is simple. Have the original notes from this person been produced?" Bondi hesitated. The whistleblower provided their recollection, which was the basis of the memorandum, she stammered, attempting to regain control of the conversation. The aftermath, fallout, and political repercussions. As Justice Barrett left the committee room, the Capitol's hallways were alive with tension. Capitol Police provided additional security, a necessary measure considering the gravity of the moment. The storm of whispers, shuffling footsteps, and distant conversations marked the aftermath of what had been a pivotal hearing. The walls of Congress, long accustomed to high-stakes drama, now reverberated with the hum of journalists desperate to digest the significance of the confrontation that had just unfolded. For those who had witnessed it firsthand, the spectacle was nothing short of breathtaking. In an instant, newsrooms nationwide were in overdrive, scrambling to piece together the story. The once impregnable allegations against Barrett, which had seemed so convincing earlier in the day, were now revealed as little more than a carefully crafted mirage. News channels switched from their regular programming to dedicate hours of airtime to breaking down the dramatic developments. Right-wing outlets seized the opportunity to rally around Barrett, framing the situation as an orchestrated attack designed to tarnish her reputation. Documents debunked. "Justice Barrett exposes false allegations," declared one prominent conservative network, showcasing clips of Barrett's calm, almost serene dismantling of Pam Bondi's case. The whistleblower's shadow, speculation, and suspicion. Despite Barrett's victory, the shadow of the mysterious whistleblower who had provided the documents loomed large over the entire scandal. The individual's identity was kept secret, but their role was of immense consequence. As the public digested the outcome of the hearing, speculation swirled about the motives behind the whistleblower's actions. Was this individual a disgruntled former employee looking for revenge? Could they have been a political operative, strategically positioning themselves to take down a Supreme Court justice they disagreed with? Or was this person simply duped, unknowingly manipulated into supplying false evidence to discredit Barrett? As the weeks passed, investigative journalists began to peel back the layers of the whistleblower's background. The findings were damning. Reports emerged revealing that the individual had never worked in the positions they had claimed. They had no direct knowledge of the inner workings of the Supreme Court's nomination process. Yet, despite these glaring holes in their credibility, they had managed to gain access to confidential information and create documents that appeared legitimate on the surface. Their ability to fabricate such convincing evidence raised serious questions about their true intentions. The media frenzy surrounding the whistleblower intensified as the public learned more about the gaps in their story. With each new detail that surfaced, it became increasingly difficult to separate fact from fiction. Institutional change, a silver lining. In the wake of the scandal, however, there was a sliver of hope that emerged from the chaos. 2 weeks after the hearing, the Supreme Court, recognizing the need for transparency in light of the episode, introduced a set of new measures designed to provide more clarity in the confirmation process. While the court did not directly acknowledge the bonsai incident, it was clear that the fallout from the episode had catalyzed institutional change. The new guidelines required justices to document and disclose their pre-confirmation meetings more thoroughly. They were now obligated to record substantive conversations and provide clearer explanations for potential conflicts of interest. This was seen as a long-overdue step toward ensuring greater accountability in the judicial confirmation process. For many, it was a sign that the public outcry surrounding Barrett's case had not been in vain. In a rare interview, a senior Supreme Court justice, who had not been involved in the bonsai controversy, admitted that while the specific allegations against Barrett had been disproven, the episode had raised valid concerns about the lack of transparency in the court's internal workings. Sometimes, the justice remarked, it takes a crisis, even one based on false premises, to drive necessary institutional change. This candid acknowledgement served as a reminder that even the most well-respected institutions must evolve in response to public scrutiny, especially when trust in their processes is at risk. The final vindication, a matter of fact. 6 months after the hearing, the legal community and the public alike were given a powerful reminder of the true strength of Justice Barrett's independence. In a landmark case, Barrett delivered a majority opinion that directly contradicted the claims made in the falsified documents. The decision, which had far-reaching implications for American jurisprudence, cemented her place as a justice committed to the law above all else. The case itself was one of the most significant rulings in recent Supreme Court history. The decision not only reinforced Barrett's reputation for impartiality, but also served as a reminder of the power of the judicial process. Her opinion was a testament to her legal acumen and unwavering commitment to justice, unaffected by the outside noise that had surrounded her earlier in the year. However, despite the clear professional victory, there were whispers in certain circles about the broader impact of the bonsai scandal. Some wondered whether the intense public scrutiny had subtly influenced Barrett's decision-making. Would the immense pressure to vindicate herself have impacted her judicial reasoning in ways that were impossible to measure? While no one could definitively answer that question, the fact remained that Barrett's decision reaffirmed her strength in the face of overwhelming adversity. The power of methodical verification. Ultimately, the dramatic confrontation between Justice Barrett and Pam Bondi stands as a stark reminder of the enduring power of facts, verification, and careful consideration in a world where accusations can go viral before the truth has a chance to catch up. In an era where misinformation spreads at the speed of a tweet, it is often the patient, methodical examination of evidence that separates truth from fiction. While Bondi's allegations were quickly debunked, the episode itself highlighted the dangers of rushing to judgment in the age of social media and 24-hour news cycles. As the political dust settled and the public moved on to the next issue, one thing remained clear. When presented with facts, context, and a clear commitment to truth, the power of evidence could still prevail. Justice Barrett, through her composed and precise response, demonstrated that even in the face of scandal, integrity and verification were the ultimate weapons in the fight against baseless accusations. The political landscape had learned a valuable lesson. Facts, not narratives, were the true markers of justice.